As a person who's worked in law enforcement before, you're familiar with the concept of kind of securing a scene, right?
Correct.
And doing a protective sweep of a scene, right?
Mm-hmm.
And you remember when the police asked you if they could do that, refusing to allow them to go inside before you to do a sweep?
I didn't refuse anything, sir. All I did when I walked in the house is tell them I had two dogs in there, and one of them happens to be an American Pit Bull Terrier, and I, being a one connected to law enforcement, two understanding of possible feelings about seeing a dog like that, I wanted to assure him that he was one, friendly, and two, that I would go in with him. That was the only reason that I never refused anything. They never told me to stay out.
So if the police officer were to say something to the contrary, they are not telling the truth. Is that correct?
I would believe that that's the case. I don't remember anybody telling me to stay out of the house.
Mr. Doran, on your direct examination, we watched video from your home surveillance system. You'd agree that nowhere in that video you can see my client breaking or destroying any of the property inside of the residence, right?
The video camera position does not allow that, correct?
And you testified about some broken mirrors. Were there two or more of those broken mirrors?
There was.
I'm sorry, I'll clarify my question. Were there two of them or were there more than two?
There was three in total. I had
Three
four
in total.
mirrors that I just put up. Three of the four were broken. There are all kinds of still pictures of those mirrors available as well.
You provided those to the police?
I sure did, and they took them while they were there as well.
You didn't provide the police any photos or video clips of the condition of that property prior to September 6th, did you?
No, I was not asked for it. After I updated my home gym, I'm proud of what I've obtained as far as my weights, and I got all of this stuff. So after I straightened it up, I always take pictures of my workout area, post it to social media. So yeah, there are pictures of it in its prior state.
And with respect to this motorcycle, you're aware that my client, he does mechanical work, right?
Yeah.
And the motorcycle was broken down into a disassembled state, right?
It was.
You testified that the motorcycle was broken down, it was disassembled on this date, right?
It is a project bike, correct?
And that bike is not seen in the video we watch on direct examination, is it?
The bike was not in any pictures. It was in the room, and like I said, when the picture would go to live view, it stopped recording. So in the interim of that, where he was going into that room, that's when the bike become missing.
People's Exhibit 2 was a series of text messages that you provided to the police as screenshots, right? You still have those in front of you?
I do.
Okay. And Your Honor, if I could have a moment to confer with the prosecutor.
Yeah, go on. It's right.
Okay. And that's how it appears for him?
Yes.
Okay. So, Mr. Dorn, generally speaking about those text messages, the gray is text messages received from Zachary. The green is text messages sent by you, right?
Yes.
And the green ones are cut off in almost all occasions that a green message appears. It's cut off, right?
I'm not sure why that is. I think because of the way they were copied from the text messages as they were received, that's not intentional.
And you never provided, no one ever asked you to provide your phone for forensic extraction purposes, right?
No.
So you took these photos as still frame screenshots on your phone and just gave them to the police, right?
I did.
So when a text message is cut off, that would be because of the way that you framed the picture. Is that fair to say?
If there was anything cut off, normally what I do is take another screenshot to show the rest of the pictures, so I don't know where the other part of that is in reference to these copies that I have here. I don't know if they're available somewhere else or whatnot. I
Okay.
generally, would make sure that you have the entire message to make myself clear.
And you're testifying that you did do that in this case, you provided the entire message to ensure that it's clear.
I can't tell you 100%, but I'm pretty sure that's how I sent them or done them. That's how I do it all the time.
And the prosecutor marked these, the ones you have in front of you, as people's 2, and then I believe there are small numbers 1, 2, 3 at the bottom. Is that how they appear to you?
Yes.
So if you could go to page 3, which is people's 2, small 3. You see the part where Zachary says, just put the key in the mailbox?
Yes.
These text messages were sent before Zachary entered the home. Is that correct?
As not having the date there in reference, I can't tell you that. All I see is the time. If it had the date of this, incident, I can tell you that.
And to be clear, the time is the time in the top left of each of these still frame photographs. That is the time displayed on your phone, not necessarily the time these texts were sent or received. Is that correct? Correct?
Yeah.
Okay. The only time a date appears is on people's 2, 3, which is Wednesday, September 10th at 7:43 p.m.
Could you repeat that question, please?
I'm sorry. On the 3rd page of people's exhibit 2, the second picture on the bottom, there is a date and timestamp on that, right?
Yes.
Okay, but other than that, there are no dates and timestamps.
Correct.
And
To my knowledge, like I said, I still have the phone and I haven't deleted any of the stuff. You can take my phone right now and do whatever forensics you want to it at this time, no time.
Your Honor, I have nothing further at this time.
Any additional questions?
Yes, Your Honor. Sir, just to clarify, was any of the property that you told the court had been damaged in this incident, was any of that damaged prior to the defendant coming into your house?
No.
Nothing further, thank you.
All right, thank you. You may step down. Thank you, sir. Any additional witnesses for the people?
None from the people.
Any witnesses for the defense?
None from the defense, Your Honor.
Do I have a motion?
Yes, Your Honor, people will move to bind over as charged in count 3 tagging along.
Response.
Object to bind over, Your Honor. With respect to count 1, the home invasion, 2nd degree, that charge in this case is predicated upon a larceny having occurred within the residence. Your Honor, I would ask the court to consider in making the bind over decision that there has to be some evidence from which the jury could infer that Mr. Doran, my client, Mr. Doran, intended to permanently deprive his father of the property in question.
When you say permanently deprived, but that doesn't have a time on it. I mean, if he's going to deprive him of property at any point in time, that can constitute the larceny.
I understand that the court could reach that conclusion. I would ask.
Well,
the
but
court
that's
to
the law,
consider,
isn't it, counsel?
Your Honor, I would ask the court to consider that the evidence, the testimony taken today established that Mr. Doran took things that belonged to him that were contained within a safe, which was returned to the owner. That's what I would ask the court to consider in this bind over decision. I would also ask the court to consider, with respect to the home invasion second, that the people's evidence that Mr. Doran did not have permission to enter that home, I think significant questions are raised when the evidence establishes that Mr. Doran has a key to the home and that there are text messages asking his father to leave a key outside, presumably before this occurred. So I would ask the court to make the inference that if Mr. Doran had a key in his possession that was given to him, that he believed that a reasonable person could believe he had permission to enter that home. What those text messages don't establish is that he
You're
didn't.
going to say that I'm to infer from all of this that he had permission to enter that home, hook up a chain to his truck to something in that home and drag it out of that home, and that somehow he had permission to do that?
Your Honor, I think those text messages are discussing, and what the witness testified is that there are items in that home that belong to my client that he has not retrieved, that his father testified he wants him to retrieve. And that's our position on what was going on in that video and what happened today, or at the date of the incident.
Okay. Oh, I don't really need much, but
Your Honor, I think even if, as it relates to the lockbox, even if the court didn't find a permanent intent to deprive there was still testimony about the bicycle, which to my knowledge was not returned. So there's certainly a permanent intent to deprive there. I would again ask the court to bind over.
And Your Honor, may I very briefly reply?
yes.
Just to touch on count two is malicious destruction of personal property between 1,000 and 20,000. We did hear testimony regarding surveillance cameras and mirrors inside the home. I don't believe we heard any testimony with respect to a 2003 Saturn as reflected in the people's information. So I would just ask that that not be considered in the bind over decision.
Right. Well, I've listened to the testimony of Mr. Doran, and what is clear with reference to count one, as to whether or not the defendant had permission to enter the home, the witness clearly has testified that he did not have permission, nor did the circumstances under which the court views the defendant in the home could lead the court to the conclusion that somehow he was there with the permission of the homeowner, his father. Further, it would seem to me that if indeed he had permission, or if I'm somehow to infer the request to leave a key as somehow, or that him having lived there, as many kids may have at some point lived in their parents' home, as constituting a constant permission. Had he had permission, it would seem to me that he could have said, "Can I get into the house and remove these items in some way?" But that's not what occurred here. And I don't think that I could make a reasonable inference that that's what he was doing. He was forcibly trying to take items, and some of those items belong to his father, namely the lockbox. When he's in the premises, and I can take Mr. Doran's estimate of the value of the property that is destroyed, he has indicated that with the mirrors, it's going to be around $1,500, but he said in excess it's going to be over $1,000, and that was the property that was destroyed. So I would specifically find that people have shown that he entered that the defendant did enter the premises, and that while present in there, did commit a larceny in terms of removing the box that contained the weapons and ammunition.
This moment right here is wild. Shouting perjury at the prosecutor almost never ends well. The judge is about to reestablish control, and trust me, he does not play around.